So, Rule 17, subpoenas. Rule 17, subpoenas. In every criminal case, the prosecuting attorneys and the defendant have the right to compel the attendance of witnesses and the production of tangible evidence by service upon them of a subpoena to appear for examination as a witness upon the trial or other hearing. For attendance of witnesses, form issuance, a subpoena shall be issued either by the clerk of the court in which the case is filed, or by one of the counsel whose appearance has been entered in the particular case in which the subpoena is sought. It shall state the name of the court and the title of any of the proceedings, and shall command each person to whom it is directed to attend and give testimony at the time and place specified therein. B. Pro se defendant. Subpoena shall be issued at the request of a pro se defendant, as hereinafter provided. The court or a judge thereof, in its discretion, in any case involving a pro se defendant, may order at any time that a subpoena be issued only upon motion or request of a pro se defendant and upon order entered thereon. The motion or request shall be supported by an affidavit stating facts supporting the contention that the witness or the items sought to be subpoenaed are material and relevant, and that the defendant cannot safely go to trial without the witness or items which are sought by subpoena. If the court is satisfied with the affidavit, it shall direct that the subpoena be issued. C. For production of documentary evidence and of objects, a subpoena may also command the person to whom it is directed to produce the books, papers, documents, photographs, or other objects designated therein. The subpoenaing party shall forthwith provide a copy of the subpoena to opposing counsel or directly to the defendant. If unrepresented upon issuance, the court on motion made promptly may quash or modify the subpoena if compliance would be unreasonable or oppressive. The court may direct that books, papers, documents, photographs, or objects designated in the subpoena be produced before the court at a time prior to the trial or prior to the time when they are to be offered in evidence, and may upon their production permit the books, papers, documents, photographs, or objects or portions thereof to be inspected by the parties and their attorneys. D. Service on a minor. Service of a subpoena upon a parent or legal guardian who has physical care of an unemancipated minor that contains wording commanding said parent or legal guardian to produce the unemancipated minor for the purpose of testifying before the court shall be valid service compelling the attendance of both said parents or legal guardian and the unemancipated minor for examination as witnesses. In addition, service of a subpoena as described in this subsection shall compel said parent or legal guardian either to make all necessary arrangements to ensure that the unemancipated minor is available before the court to testify or to appear in court, or show good cause for the unemancipated minor's failure to appear. E. Service upon. Unless service is omitted or waived, a subpoena may be served by the sheriff, by his deputy, or by any other person who is not a party and who is not less than 18 years of age. Service of a subpoena may be made by delivering a copy thereof to the person named. Service may also be made in accordance with Section 2430-21043. Section 2430-21043 CRS. Service is also valid if the person named has signed a written admission or waiver of personal service, including admission or waiver signed using a scanned or electronic signature. If ordered by the court, a fee for 1 day's attendance and mileage allowed by law shall be tendered to the person named if the person named resides outside the county of trial. F. Place of service. In Colorado, a subpoena requiring the attendance of a witness at a hearing or trial may be served anywhere within Colorado. 2. Witness from another state. Service on a witness outside this state shall be made only as provided by law. G. For taking deposition issuance. A court order to take a deposition authorizes the issuance by the clerk of the court of subpoenas for the persons named or described in the order. H. Failure to obey subpoena. 1. Contempt. Failure by any person without adequate excuse to obey a duly served subpoena may be deemed a contempt of the court from which the subpoena issued. Such contempt is indirect contempt within the meaning of CRCP 107. The trial court may issue a contempt citation under this subsection 1, whether or not it also issues a bench warrant under subsection 2 below. 2. Trial witness. Bench warrant. When it appears to the court that a person has failed without adequate excuse to obey a duly served subpoena commanding appearance at a trial, the court, upon request of the subpoenaing party, shall issue a bench warrant directing that any peace officer apprehend the person and produce the person in court immediately upon apprehension, or, if the court is not then in session as soon as court reconvenes. Such bench warrant shall expire upon the earliest of I. The submission of the case to the jury, or II. Cancellation or termination of the trial. B. Upon the person's production in court, the court shall set bond. CRCP 17. CRCP 17. Coming up next, venue. Venue.